Hello and welcome to Theater Operations Unleashed, the monthly show that explores the ins and outs of theater operations, management, facilities, and design. I'm your host, Raymond Kent. In each episode, we will be focusing on management, operations, design, trends, and best practices in the performing arts. I hope to bring you both insights from my 4 decades in the industry, as well as engaging conversations with theater professionals about the challenges and rewards of their work. We'll also cover a wide range of topics from budgeting and scheduling to marketing and audience development, theater technology, and many other related topics. Whether you're a theater maker yourself or just interested in the industry, I hope you'll find this podcast informative and inspiring. So sit back, relax, or lean in, and let's dive into the world of theater. Hello and welcome back to Theater Operations Unleashed. I am Raymond Kent. And today we're diving into a topic that doesn't get nearly enough attention in the performing arts world, even though it shapes everything that we do. Of course, I'm talking about employment law. I'll start by saying I am not a lawyer, and this is not intended to give legal advice. You should always seek the counsel of a licensed attorney to make sure you are complying with any laws or framework. Now, I know this is not a glamorous topic, doesn't sparkle like lighting design or stir the soul like a great performance. But here's the truth. If you don't understand employment law, you can't understand accessibility. If you don't understand accessibility, you can't run a modern performing arts organization. This is one of those foundational topics that quietly determines whether your organization is safe, ethical, compliant, and capable of supporting disabled artists and workers. So let's get into it. So let's look at how performing arts workforce isn't one workforce. It's one of the biggest challenges in our field is that we don't have a single type of worker. We have a full-time staff, part-time staff, maybe seasonal hires, overhire technicians, union performers, non-union performers, designers, directors, stage managers, teachers, artists, guest artists, independent contractors, and volunteers. And every one of those categories carries different legal implications, different rights, different protections, different obligations for the employer. If you don't understand who is who, you can't comply with the law. And you can't provide accessible employment. And that's where so many organizations stumble. They assume everyone fits neatly into the same box, and they make decisions based on tradition instead of legal reality. So what is the ADA? Who does it cover and who doesn't? Let's start with the big one. Americans with Disabilities Act, Title I. Title I covers employers with 15 or more employees, and it covers employees, not contractors, along with applicants for employment and workers in any department, whether artistic, technical, or administrative. This means performers are employees if they're hired, paid, directed, and scheduled by the organization. Stage managers, technicians, front of house staff are employees. Teaching artists might be employees depending on how much control the organization has over their work. Designers might be employees or contractors depending on how the contract is structured. And here's the part that trips people up. If you treat someone like an employee, the law will too, even if you call them a contractor. Misclassification is one of the most common legal risks in the performing arts, and it's one of the biggest barriers to accessibility, because contractors aren't covered by the ADA. If you misclassify someone, you may be denying them rights they're legally entitled to. So what does it mean to have reasonable accommodations? Under the ADA, employers must provide reasonable accommodations to qualified employees with disabilities. And accommodations apply everywhere, backstage, on stage, in the office, in the classroom, in rehearsal, and so on. If a disabled performer needs an accessible dressing room, that's an accommodation. If a stage manager needs different calling stations set up, that's an accommodation. If a designer needs remote meetings, that's an accommodation. Accommodations aren't favors, they're legal obligations, and they're part of building a workplace where disabled artists and workers can thrive. Essential functions really is a term that often gets thrown around with employment, and is often one of the most misunderstood concepts of the ADA. Every job has essential functions, the core tasks the person must be able to perform with or without accommodation. But in the performing arts, essential functions are often defined by tradition, not necessity. We've all seen job descriptions that say things like must climb stairs, must stand for long periods, or must lift 50 pounds. Those requirements used to be essential, but technology has changed the work. Motorized rigging, personnel lifts, adjustable workstations, and team-based lifting have reshaped what's actually necessary. The law requires employers to define essential functions accurately, not aspirationally. If a task can be reassigned without harming the production, it's not essential. And that's where accessibility and job design intersect. So let's look at Section 504, the federal funding trigger. If your organization receives any federal funding, directly or indirectly, Section 504 of the Rehabilitation Act applies. This includes NEA grants, state arts agency grants, federal education funds, federal capital funds, and pass-through grants from municipalities. Section 504 requires non-discrimination, accessible employment practices, a designated 504 coordinator, a self-evaluation, and a transition plan for removing barriers. Most organizations have never completed these requirements, but they're not optional, and they are essential for accessibility. One of the hidden layers is the state and local laws. Many states have disability employment laws that are broader, stronger, and more protective than the ADA. Some cover employers with fewer than 15 employees. Some require accessible emergency procedures, and some mandate anti-discrimination training. Some require accessible hiring processes. Some have stronger retaliation protections. If you operate in multiple states, or if you tour, you must comply with the strongest applicable law. Ignorance, unfortunately, isn't a defense. Unions and collective bargaining agreements have to meet accessibility. Union contracts, whether AEA, IATSE, AFM, or USA, intersect with accessibility in important ways. Contracts define work hours, breaks, safety requirements, job duties, and work rules, but union contracts cannot override federal disability law. If a disabled worker needs an accommodation, the employer must engage in the interactive process, even if the contract doesn't mention it. Accessibility, again, isn't negotiable. Now let's look at volunteers and interns. This can get a bit in the gray zone, and volunteers and interns are often treated informally. But interns may legally be employees, and volunteers may be covered by state law. And disabled volunteers are protected under Section 504 if the organization receives federal funds. If someone is performing work that benefits the organization, the law may consider them an employee, regardless of what you call them. And that matters for workers' compensation, accommodations, safety, liability training, and access to backstage spaces. Clarity protects everybody. So employment law in the performing arts, it's complicated. Not because the laws are unclear, but because our workforce is diverse, fluid, and historically informal. But accessibility requires structure, it requires clarity, and it requires understanding who your workers are, what rights they have, and what obligations you carry. When you get this right, you don't just avoid legal risk, you build a workplace where disabled artists, technicians, administrators, and educators can thrive. And that's the goal. So in the next episode, we're going to take a look at some accommodation for performers with disabilities. We'll examine the legal framework for accommodation in the creative space, the artistic case for inclusive casting, and the growing body of disability arts practice that reframes disability not as a barrier to performance, but as a dimension of creative expression. Thanks for taking the time today to listening to Theater Operations Unleashed. We hope to see you next month.